These days there is this discussion about the 19th Amendment to the Constitution to be replaced by the 20th Amendment. Regarding this, there was an interview with the Hon.Minister of Justice, Mr. Ali Sabri, in a program called Salapuna in the Hiru TV on the 14th. Now, in that one, there were many questions asked, but some of the most vital questions that should have been asked was not asked from the minister, for whatever reason. So, the purpose of this presentation is to raise some of those questions, because the belief that the 20th Amendment will bring about a better situation than the 19th Amendment, is it a pure hypothesis, or is there any basis to trust that view? Can the very changes of some of the errors of 19th Amendment be changed in a way to make the things worse than even the 19th Amendment or not? And there is that possibility. Judging from the past, we know that mere amendment does not mean salvation. It can make things worse. There is that singular poem where it is said that somebody went to the smith to get his sword mended, and the smith made more cracks in the sword than resolving his problem. As we have that all the time, let's ask some of these questions. The minister is also a senior lawyer and a president's counsel. So therefore, these questions that are asked are very relevant from a person of that sort. Now, the first question is, does the minister reject the following principles? A, that the people need to be protected from the all-powerful state. Fundamental norms about political science is that the state is so powerful that people need a state legal mechanisms to protect themselves from the state. And the good legal system provide a very solid basis in order to prevent the state interfering with the legitimate rights of the people. Now, is this principle being rejected now? Second issue is that it is also a recognized principle that the judiciary is the guardian of in charge of protecting the individual when the individual comes into conflict with the state. Now, that again is not a controversial in any way. Now, is this principle a bad principle for Sri Lanka? Is not the Supreme Court and the judges the real guardians when it comes to their protection of their rights? Next question is, if it is admitted that they are the guardians, then do not the guardian require a protection? When you are dealing with powerful state and you have to make decisions which on the basis of principles to protect the individuals as against the state, it is quite normal and natural that they could get into serious problems. That's a political legal issue. Now, since the judges are the protectors, should not they have that protection, and should not that protection be within a framework of law, not on the goodwill of any person however high he may be. That the following from this is the issue when it comes to the protection of the judiciary is not the principle of security of tenure, a fundamental principle. This is some principle that is not suitable for Sri Lanka. That a person who is holding a position like Supreme Court judge, Appeal Court judge and High Court judges as well as any other judge having to make very serious decisions, therefore likely to offend one party or the other, needs a legal protection, legal framework of protection. Now, should it be left purely for the president, however good or clever he may be, to decide on the dismissal of a judge? Is not that one of the most violations of one of the most fundamental principles on which the entire judicial independence rests? The Honorable Minister mentioned many times our judges are very good and they are always independent, and nobody wants to challenge them. But there is a framework of protection, and that's an independent issue as to the subjective judgment of anybody about giving a good certificate to the judges. Is there that protective umbrella, and is it bad for Sri Lanka to have such a protection? From this we come to the most fundamental issue on which all constitutional problems on Sri Lanka hangs. That is the problem of judicial review. Why things went bad in Sri Lanka from 1972, then to 78 and up to now is the issue of a decision that was made to remove the judicial review power of the judiciary. The implication is this: judicial review means that when a new law is made or some law is there in the book even from the past, the judges can go into the law, Superior Court judges, and find whether the law itself is legal, because preserving legality is the very foundation of stable society. So if the law itself is bad or proposed law itself is bad, then the judiciary must have the capacity to say that no, this law will harm the country and the system. Now this was what was removed in 1972 and thereafter, and nobody talks about this issue. However, does the minister think that Sri Lanka's constitutional crisis could ever be resolved without dealing with the issue of judicial review and restoring the power of judicial review to the judiciary? Is not the judicial review power the real cornerstone or the foundation stone on which the judicial independence rests? We know from the history, from Chief Justice Marshall in United States up to all the developed country jurisprudence, including Sri Lanka's own jurisprudence up to 1972, that the ability to say that something that is done by the government or the highest officer is wrong has been recognized as a very fundamental element of the independence of judiciary. Brace girdle case is the famous example in Sri Lanka, where the Governor General decided to deport someone, and then the judiciary decided that this was illegal. Is such a judiciary bad for Sri Lanka? Now that's the issue that is not even being spoken about, and from this one important practical conclusion is derived. The practical conclusion is that according to the Honorable Minister, that in order to improve the efficiency in the country, in order to get the businesses working, the state departments working back again, and to have a kind of a climate which would attract local and foreign investment is the foundation for bringing about the foundational principle for bringing about the 20th amendment. Now, is it in fact possible? Is it possible to make the state machinery that has collapsed so deeply ever since 1978 be revived within its own framework, 1978 constitutional framework? And will the people merely get attracted for investment, trusting purely on a single individual, however good or clever or the person may be? Is it the reason why we don't have investments, or is it more structural? The structures have been collapsed, and there had not been, although this 17th, 18th and 19th, all these amendments were talked about, this structural problem was not addressed. So it is, minister seems to blame the various commissions, for example the police commission for the increase of crimes, or other commissions for increase of various faults. But that would be when the entire structure is rotten, and appointment of mere commissions with hardly any power and hardly any resources, being given the task of trying to revive these institutions. For example, the police. That's a historical question that has really going to serious reflection and study. For example, 2010 to 15 government, when they put about 38 or 39,000 people all at once, merely in order for the purpose of giving jobs to the police, virtually you created a huge load of people who are not qualified for their jobs, but who are there. And now some of them have risen in rank, because with seniority you rise into ranks. How to get rid of that? Will the 20th amendment be able to effect reforms of significant nature which will bring back the policing system into a working condition? We are not talking about ideal condition, working condition, even as it existed up to around 1960s. There was a certain system, not a perfect system at all, but a certain working system. Without drastic reforms of which are of structural nature, can that be done? And has it not to be done within addressing the problem in a more serious way than by merely saying that we are dealing with one amendment and we are creating another one, and then everything will be back to a golden age? Is it a serious political exercise? Is this 20th amendment a serious political exercise with the view to improve the economy, with the view to strengthen the people's confidence in government, with the view to get highest participation in economic and all other matters from the people? Will that result, and will all that merely depends on an individual? These are matters of principle, and I think the Minister of Justice should have been asked these questions.